I'm very jealous of Mr. Bloom. First, because he had a very nice PowerPoint presentation with rich content and colors, and I have, lawyers trying to do some stuff with PowerPoints never ends up in great success. Our language is words. So where I'm going to talk, and you will find words and not so many images. But the real reason why I'm jealous is that because he speaks of a team and a collaborative effort to reach and engineer something and bring a product to the market. And I can tell you that as a lawyer, you enter a room full of engineers. Basically, they show you, if they accept not to shut the door and keep you outside, they give you a nice seat at the very end of the table and do not explain to you anything in words that you can understand. And discussions stop. People do not dare talk again or among themselves about the projects. So it is very hard for a lawyer to try and enter this world of engineering and really understand what are the stakes. And I suppose that it is mutual, meaning that the engineers are really fed up with the in-house counsels or external attorneys who really don't understand what this is about. And the really interesting aspect is to try and bridge these misunderstandings and really try to find out how a lawyer could understand what your project is about, what your product is about. And we are going through maybe a few examples during the next half hour to try and show you how a lawyer would think of certain issues raised by mobile communications. Please interrupt me, throw eggs, tomatoes, I have my exit door over there. But I'll try to keep the half an hour slot. So, this is how I would like to proceed. First, one slide about Solomo. Second, an overview about mobile communications, legal issues. Then we're going to take two examples. One about flying data, or data in the cloud if you want. And the second would be to discuss about a very recent and interesting ruling by the Swiss Supreme Court about the Google Street View services that maybe you have heard of. And then we will conclude. So the Solomo trend, the social, local, mobile, this is an acronym that has been hashtagged on Twitter. The whole idea is, of course, a business and marketing idea. The idea is that these wonderful global businesses want you as a consumer to live an enhanced experience when you access their platforms or you use their services. And of course, they promise you a better experience and a better value. Meaning that they have to find ways to share data to make sure that you are put in the middle of a community with interests that you share. Shopping interests, political views, taste. It's all about the social aspect of these new marketing or devices and projects. Second, it has to be local. You are not interested when you are with your smartphone, understanding what is going on in Lausanne. You are not interested in receiving news or updates about the Starbucks store in San Francisco. You are very much interested in knowing what's going on in Lausanne with certain brands and certain businesses. And it has to be mobile, it has to be accessible everywhere, anytime. We will focus on this presentation on the mobile aspect and from a legal perspective. Mobile legal issues, many of them. First set of issues, regulatory issues. Licensing. Have I to apply formally to provide this kind of services as a telecommunications services provider? Or is what am I doing something else? And I need to convince the authorities that this does not need to be regulated the same way as incumbent operators, for example. interconnection, this kind of stuff. Very classical issues coming from the telecommunications world, but that apply to a certain extent to mobile communications. Second set of legal issues, consumer protection. Many issues now about spam, security on mobile devices, deceptive practices. Can we still require you to read the 50 pages terms of Apple when you're on your smartphone trying to access the service and click I agree before you can use that service? There are other issues, older issues linked with liability. I set up a network. Am I responsible for the information that is transmitted over this network, or can I just set up the backbone, set up the infrastructure, and then close my eyes, take my nose off, shut my mouth, and pretend that I don't know anything about, copyright infringements, obscene material, illegal material being transmitted over this network? This is also very interesting legal issue that has been around for many years. New questions, advertising and mobile, also a very new trend. Now lawyers are being asked to render legal advice about this. And the next one is data protection, privacy and security surveillance, and this is the one we are going to focus about. So this is an introduction, very traditional legal introduction. This is what is the scope of what could be the presentation. I'm trying to reduce it to something for the half hour or the next 20 minutes. For a lawyer dealing with data protection issues in the mobile communications world, the first question to ask is whether you are dealing with PII or non-PII. Have you heard about this acronym PII? It means personally identifiable information. It's like, the to be or not to be, or does God exist question that you have to ask yourself before trying to assist from a legal perspective. PII is defined, but this is a Wikipedia definition, so it's not a legal definition, as information that can be used to uniquely identify a single individual, fine, but also information that can be used with other sources to uniquely identify a single individual. And the problem we have is not about information that basically gives you the basics, the details of the person, name, address, telephone number. This is not the legal issue. The legal issue is about having bits of personal information in some databases and aggregating this database with other sources of information that per se, by themselves, would not be able to reach the point where you can identify an individual, but linked together will provide this kind of result in output. In the US, you have a rather restrictive view of what is PII. Traditionally, the US do not protect privacy and data protection as much as continental Europe, for example. But there is no single unified definition of PII in the US. So you have different agencies taking different views, different states, different courts, addressing the issue in a different manner. But basically in the US, the trend is to consider that you have to be able to identify a single individual with the information that you are discussing. In Switzerland and in the EU, we have a totally different view. It's written in the European Data Protection Directive that it can be identified or unidentifiable, same level. So the complexity of the legal issues in Europe is much bigger, because you have at each moment to verify and check whether the information you have can identify someone or could, linked with other sources of information, lead to that result, which is not a totally different approach, but a more extensive approach. You also have an additional issue I will not discuss here, at least in Switzerland, where legal persons, i.e. companies, can benefit from data protection, personal data protection. In the US, only single individuals, natural persons. So, basically, your legal assessment of the situation will start with trying to figure out whether you are in the PI world or the non-PI world. This image is not fair because now everything basically is PII. So it's just a growing set of information. And the non-PII data, which as a lawyer is much easier to deal with, just reduced to basically nothing. Legal scrutiny and obligations are there if you end up with this is PII data and I have to deal with that. The non-PII information are non-regulated, which is good. Makes your task easier, makes the client happy because he doesn't have to deal with you for months before he can progress on the project. Unless, I'm sure there is something here I can show. Try here, yes. Unless you get back to the PI world by data mining, profiling, de-anonymization, aggregation. Let me give you an example. After weeks of negotiations intense negotiation with a world-famous search engine in 6 letters, these guys tell you, and my client was really a big shot client, they tell you, we will process all the information and all the traffic of your websites worldwide. No problem, we can do that. And we will keep a log of all IP addresses. Thanks so much. Now, when the agreement ends, what are you going to do with this data? Because, of course, IP addresses are PI data. And they tell you, don't worry. What we will do is we will just delete the last digit of the IP address so that you are confident that this is fully anonymized data and you don't have to take care of that anymore because we are not interested in the last digits, we're interested in the first positions. Is it sufficient or not? Clearly not, because if you have another database with IP addresses, you can certainly match these addresses and end up with PII again. We were unable to reach a better agreement. But basically, there are some companies around the world that have gathered PII information, huge amount of PII information, just deleted what they think would be necessary to get out of any regulation, but this might come back into your face later down the road by mixing databases. Couple of examples of these principles, PII, not PII. 2 examples, one, regular day at work, so flying data in the cloud, and second would be the Google Street View about geodata. So flying data in the cloud. My advice right here, do not let the lawyers drive you there. Because we can spend days, weeks, if not months, arguing among colleagues from different jurisdictions about what is legal, what is desirable, what is acceptable. So if you are dealing with data protection issues in the cloud, do not have a strong legal sponsor in this, because your flight will never take off, okay? And if it takes off, you really don't know when you will arrive and where you will arrive. Especially if you have an EU company, European company on the one side, and a US company on the other side, it's very difficult, even among specialists in privacy law, to really understand what might be different and what might be similar. So this is about, a time where you had all the sensitive information locked in your office in a single binder. A kind of an alignment between legal ownership and physical possession of the information. If you possess the information, basically you can control its dissemination, its distribution. Now we're at a time where basically there is no way for you to really understand where your data is exactly and to access it immediately. You have to go through a platform, you have to go through a service, you have to go through an ISP, you have to go to a cloud provider before you can access this information. And even in the agreement or by law it says that you are the legal owner of this information. Nevertheless, you have to go through an intermediary to access it, which makes your position much more vulnerable. So these flagging dates are just examples, bring your own device to work. So you have lots of personal information here that will be used within the premises of a company. Then, and it happens, you have to terminate the relationship, the employment relationship with that employee. The laptop, the information on the laptop, has it been backed up? Is it information that you can access? With prior information of the employee, but you have just terminated the employment, so the employee might not be very much willing to open the laptop and let you go through the emails. So it is a situation where it is extremely difficult concretely to address if you have people coming to the office with their own device. It's more and more common. Work at home, same thing, wireless communication, lots of things to discuss, cloud computing. Okay, so the idea is here with this constellation, what are the questions that I ask as a lawyer? First is what kind of data am I processing? Second, where is my data processed? And third, where does my data come from? What kind of data, PII or non-PII? If we end up with the assessment that this is PII information, that you have maybe subclasses of PII information, employee data, medical data, healthcare, are more sensitive data that requires special legal treatment and information to the person. Why am I collecting this data? What am I doing with it? And there you have a problem because basically no one knows at your client why they are doing that. So you receive a request as a lawyer saying, please make sure that this privacy policy or the terms of use regarding this service are compliant. Fine. For this to be answered, I would need certain input from the client. Why are you doing this, basically? And the client says, well, I have to ask another department. Okay, so if you ask a marketing guy at a luxury group why he wants to collect all the information of the fans of a Facebook page, he will tell you, I still don't know what I'm going to do with it, but I'm going to do something with it in the next 2 years. I don't care about the lawyers limiting my creativity and genius. I will find ways of using this data. So protect me as much as possible. And you will have the in-house legal counsel saying, gosh, this is terrible and I don't want to be responsible in 2 years down the road if we have a problem. So you have difficulties to align internally. But I'm surprised how many times a client basically does not know what is going to be the use of the data that they are collecting. And this is one of the basics of compliance with the law in terms of data protection. You have to organize not only technical measures. This is pretty much accepted by the clients. Sometimes they don't realize that they have to organize their company also to make sure that they have the right processes in terms of organization and reporting if there is a breach of sensitive data, that kind of stuff. So it's not only about technical security, it is about making sure that you have the right processes in place also for reporting internally to make sure that people know who is doing what with the data that has been collected. And it's not cash is king in data protection, it's consent is king. You have to rely, you can't basically process personal data without a justification. That's the bottom line. And the justification is either prevailing public interest, this is what the NSA and the Homeland Security uses for arguments. Most of the time, it's consent of the person submitting this data to you. And this consent, you have to be able to show that it is an informed consent, meaning that you have to be transparent about when you collect data, which data you collect, for what purpose. And this is usually where things get complicated. Cloud. So just one slide to tell you that it's very complicated because many of my clients use Amazon Cloud. Basically, they are unable to tell you, and I'm not saying my clients, Amazon is unable to tell you at a certain point of time where the data is. Okay? And the starting point for a legal analysis is to determine the facts. So if they give you the facts, your data is in this country, and this is the flow of data, I'm fine. But because the company and the structuring of a cloud network basically requires you to have flexibility, they can't even tell you where your data is exactly. The next two, so it's very difficult to end up in a situation where you have visibility on the client side. These last two issues, just one concrete aspect maybe of, or illustration of the type of legal assistance that might be required. In a big commercial dispute with big companies, one of them had headquarters in France, the other one in Switzerland, and they are fighting each other in many courts, in many countries, for money, consumers, etc. At some point, the French company thinks that there has been discussions among board members and top management of the Swiss company about the launch of a product in a certain country that might prove bad faith or trade, unfair trade. So they want to get their hands on these emails, something that is much easier in the US with the discovery proceedings, much less frequent and possible here in continental Europe. The French company gets an injunction and an order by a French court without the Swiss company being notified of this move, appointing an expert to obtain by whatever means content of the emails exchanged among board members. Then the client here gets nervous. He learned that the order was granted. He got nervous because the seat of the company is in Switzerland. There is a backup site in Switzerland of corporate emails. There is a second one in Germany. And you really don't know where the attack, but it's not a hacking attack, right? It's an order by a foreign judge to get their hands on certain information. You don't know where they will follow the rules, international treaties, and ask for the cooperation of the Swiss authorities and go to the seat of the company in Switzerland. Whether they will send a subpoena, if you want, to the hosting provider, who basically will not care, I receive an order from the court to open up access, so I will do it. And whether, if they go through this intermediary, it's going to be in Switzerland or in Germany. So you have many, many interesting questions to deal with to try and prevent. It's not about security, it's try to ring-fence information within an organization that uses international suppliers for hosting of data. Okay, where does my data come from? If it crosses borders, it's even more complicated. So the legal assessment of a situation like that, it's difficult. You don't have an easy, replicable, one-size-fits-all standard or checklist to follow. What is required is alignment among the clients to make sure that whatever you try to achieve from a legal perspective basically is backed and corresponds to what the business wants. Sometimes they just don't talk to each other, so basically you are preparing your legal assessment on the basis of what you have received from information from legal, and then you realize that business wants something totally different. And the lesson from that is maybe we should start thinking about trying to achieve best practices rather than compliance. You know, usually compliance is perceived as a first layer, and once you comply, you can try to be best in class and reach best practices level. But the more I think of it, I think that in terms of data protection, it's very difficult to secure compliance and tell your client, I guarantee you that you comply with the law, because it is subject to so many assumptions that basically 99% of the time you are out of these assumptions, so the security does not exist anymore. And it's more about trying to do its best to comply rather than showing strict compliance. Google Street View. How much time do I have? 5 minutes? Okay. Before I talked about, do not let the lawyers drive you. So maybe you have done down this journey and you end up with no decisive decision because one lawyer thinks that he's right, the other thinks that he's wrong. So basically, you go to courts. And it might be a good situation, especially in Switzerland. We have a sophisticated court system. But the problem is that you need time, because you will get a ruling maybe 3 years, final ruling 2 to 3 years down the road, and you need money because the lawyers need to eat in that period of time before there is a ruling. So it might not be available. My point is that it might not be available to startups. Many startups or innovative companies who would like to go ahead, but they can't afford to wait for a decision, 2 years before they get a decision, either positive or negative. They have to restrict their business model to what is truly acceptable. So these are the world headquarters of my firm in downtown Lausanne, using Google Street View. Get closer, you start to see cars, registration plates, people. You get even closer, you see that this is the core of the shopping district of Lausanne. You all know Google Street View. From what you have heard right now, you understand that we are talking about PII. There are faces, registration plates. So we are in this tricky world of PII information, also in Switzerland. Second, because you have a software at Google that just blurs personal features, but it's not 100% secure. You end up not only with PII, but possible infringement of data protection. Publicity rights is, in French, droit à l'image. It's the right to object being photographed in public. They had to secure my consent to be. So we have everything here in the Google Street View ruling to determine and what the rules, legal rules would be under Swiss law regarding data protection handling. That's the story. Google started its operation in Switzerland with the Google Street View services in 2009. The Federal Data Protection Commissioner in Bern asked questions. The answers were not satisfactory. So the Data Commissioner sued Google Switzerland and Google US. The first ruling came in March 2011. It was a very big blow to Google, because basically it said the service as it stands in Switzerland is not complying with the law. You have to stop it. It was not about fine-tuning. It was about not complying with Swiss law in terms of data protection. That was the Swiss Supreme Administrative Court. So Google, please stop recording and just delete from your database all the images that you have taken in Switzerland, which we would have ended up as Switzerland being on Google Earth the only country without any. So Google appealed, and there was a ruling by the Swiss Supreme Court, so no more appeals possible under Swiss law, end of May 2012. You all know Google Street View. Who would think that Google does not entirely comply with Swiss law? A minority of you. So all the others, half-half. We're in Switzerland. But at least some of you do not think that there are legal issues that should be addressed or corrected by Google in its service? I need a volunteer. You are not entirely convinced that it is a huge infringement of your privacy rights. Am I just summarizing? You are not all entirely shocked by what Google is doing. You would not require Google to shut down its service entirely in Switzerland. Okay. Let's assume that this is the current position. Before I turn to the ruling that will end here, let me tell you one thing. Very, very interesting thing. The ruling came down 31st of May 2012. Within the hour, you had a press release by Google stating that it was a huge success, that Google prevailed in reversing the prior ruling, and that Google is happy to have convinced the court in Switzerland that its service was valuable and complying with Swiss law. The press release from the Federal Data Protection Commissioner, the other part, the opposite side, was published the day after. By the time all the news agencies had relayed the success of Google, and basically what everybody will remember is that Google prevailed, which might, from a legal perspective, analyzing the case, it is not that clear. But they have won because I suppose that at Bern, the Federal Data Commissioner thought it might be a good idea to wait for a few hours to review, the press release, and that was out the next day. And the next day is too late when you try to compete on the communication with a company like Google. So the text of the ruling, it's available online. I don't know, maybe 50 pages in German, but it's an interesting ruling. But I will provide the links if you have a website. Just tell me. Google first has to inform in advance of the fact that one of its cars will go and record images of you in the street. So it's interesting from the start, because basically it means that if you want to object, you just have to take vacation or not show up and close the windows, because it's not that Google has to secure the consent of all the bypassers or the inhabitants in the street. They have to warn, I'm going to come next week. Flee if you do not agree to my taking a personal picture. But just an information on the web page is not sufficient. You have, thanks to the Supreme Court, local media have a future, because you have to publish the local media printing paper that you would come record images. Second main statement of the ruling, the limit is 2 meters. Why? There is clearly no legal reasoning behind that. Because the idea is that if you walk by a garden, even without Google, you will see something. So if you want to protect it from public view, you have to have trees or whatever, okay? But the last time I checked, the statistics about people hide in Switzerland, maybe the Supreme Court has an optimistic view of the Swiss president. But it's not 2 meters, right? Yes?
One of the reasons might be that the ability height of the trees along the properties is 2 meters.
Maybe, but still, when I look at it from the street, my eyes, so Google's camera recorder would be lower if it is to be compared to the average human, but yes, 2 meters. So what they have already recorded, they cannot record above 2 meters in the future. Okay? But they can keep what they have already recorded, and they have 3 years to comply with that. So for the next 3 years, they don't have to basically delete images taken above 2 meters. So it's not so strict about Google, and in 3 years, maybe they find another way of just with satellite or if they want to go above 2 meters, they have to secure explicit consent from the owners of the gardens. One of the funny cases about Google Street View, they were sued in all countries in the world, and they were sued in Scandinavia, in Norway, I think, because there was one man sitting in the garden in a rocking chair with clothes above the hay and nothing below. And it appeared that Google Street View, and that guy sued Google Street View, saying that there was a invasion of his privacy. In Switzerland, nobody has complained. It was the Federal Data Commissioner who took that to court. They have a specific regulation for what they call sensitive facilities, schools, hospitals, elderly homes, women's shelters, no men's shelters, courts and prison. I suppose that attorneys going out of courts would like to be recorded in their glory, but it's considered as a sensitive facility, so no images next to the courts, prisons. Complete anonymization. And the key ruling is that Google is not required to guarantee a 100% anonymization of the data that are recorded. Not required. But they can live with 1%, which is the current percentage of images that are not correctly processed by the software. So the slides will be available. The end game is what? It is a very pragmatic ruling, balance of interests. One thing interesting is that the court said, you know, but Google Street View is a very useful service to lots of communities and companies. So we should take that into account before striking it down. Public utility of a service like Google Street View. But the main issue is that it is an opt-out system, basically. So you have the right to object. You have to, in this case, to notify Google that you object, and they will take you out. But it is your burden to contact Google and tell them not to record your image, which is something totally different that the law, in the text of the law, requires, because let me remind you of the prior slide. If you handle personal data, you need the consent. And consent is not something that you will assume. With this ruling, it's the other way around. It's not an opt-in system, it's an opt-out system. Google has the right to infer consent, but I have the right to object. And this is something certainly that will have a strong impact on future data protection laws. Sorry for being so long, and thank you very much. I'm of course available for questions.